The year 2020 witnessed a legal battle that shook the foundations of the gig economy. In California versus Uber and Lyft, the state of California took on two of the biggest players in the ride-hailing industry, Uber and Lyft, challenging their classification of drivers as independent contractors rather than employees. This lawsuit gained immense attention for its potential to redefine labor laws and disrupt the business models of these tech giants. California, considered a hotbed for technological innovation and progressive policies, has long been at the forefront of labor reform. The state government argued that Uber and Lyft drivers should be classified as employees, entitled to benefits such as minimum wage, overtime pay, and protection under labor laws. This contention drew battle lines between the state and the gig economy giants. The central argument put forth by California was based on a groundbreaking labor law that went into effect on January 1, 2020, called Assembly Bill 5, AB 5. This law aimed to clarify the distinction between independent contractors and employees, making it harder for companies to misclassify workers and evade providing them with the benefits and protections associated with employee status. Under AB 5, companies must meet a three-pronged test, known as the ABC test, to prove that their workers are independent contractors. This test requires A, that the worker is free from the company's control and direction, B, that the work performed is outside the usual course of the company's business, and C, that the worker is engaged in an independently established trade, occupation, or business. Uber and Lyft vehemently disagreed with California's interpretation of AB 5. They argued that their drivers were not core to their business, considering themselves technology platforms connecting passengers with independent drivers. Classifying drivers as employees would require significant adjustments to their business models, potentially disrupting the gig economy as a whole. The impact of this lawsuit extended far beyond California. The outcome had the potential to set a precedent that could influence similar battles in other states and even countries around the world. Many gig economy companies closely monitored the developments, knowing that a ruling against Uber and Lyft could have broad implications for their operations. As the case progressed, Uber and Lyft faced mounting pressure to comply with the state's demands. However, they were not alone in this battle. The companies, along with other gig economy giants, poured millions of dollars into a campaign opposing AB 5 and advocating for an alternative solution that would preserve the flexibility of their business models. While the legal proceedings unfolded, the fate of thousands of gig economy workers hung in the balance. For some, being classified as employees would offer improved job security and access to benefits, whereas others valued the autonomy and flexibility associated with independent contracting. The divergent needs of these workers added complexity to an already contentious debate. Ultimately, in August 2020, the California court issued a ruling in favor of the state, granting a preliminary injunction that classified Uber and Lyft drivers as employees. The judge held that these companies must comply with AB 5 unless and until they could demonstrate compliance with the ABC test. This decision created seismic waves throughout the gig economy and set the stage for a potential paradigm shift in labor practices. However, the legal battles did not end with this ruling. Uber and Lyft, refusing to accept defeat, appealed the decision and sought a stay on the injunction, arguing that they needed time to adapt their operations or potentially suspend service in California. The companies contended that reclassifying drivers as employees would result in higher costs, job losses, and reduced availability of rides. In the midst of the legal wrangling, the fate of Uber and Lyft drivers remained uncertain. While some drivers celebrated the ruling, hoping for improved working conditions, others expressed concerns over potential job losses or reduced flexibility. The tensions between labor rights and the gig economy's disruptive nature continued to fuel a passionate debate on the future of work. In the weeks that followed, the Court of Appeals granted Uber and Lyft a temporary reprieve, allowing them to continue operations while the appeal process was underway. This decision offered a lifeline to the companies and a glimmer of hope for their drivers who faced an uncertain future. It also bought more time for policymakers, labor advocates, and industry leaders to explore potential compromises. The legal saga of California versus Uber and Lyft reverberated beyond the borders of the Golden State. Governments, unions, and gig economy companies around the world closely followed the case and its implications. The continued uncertainty surrounding the classification of gig workers raised fundamental questions about the evolving nature of work in a rapidly changing global economy. As the legal battle entered a critical phase, with the future of the gig economy hanging in the balance, the case of California v. Uber and Lyft became an emblematic clash, shedding light on the complexities of labor laws in the digital age. The resolution of this lawsuit had the potential to reshape employment practices, worker rights, and the very foundations of the modern workforce.